but here it has been marked as Exhibit P14. Plain ภาษา Exhibit
341 is the exhibit 13, or exhibit 14,
Exhibit
and extra
14
13.
in the recast plane.
Ah,
And Lordship may turn to page 340. This is the letter addressed to the defendant number 1 by the Deputy Secretary to Government of Mizoram Revenue Department, in which it has been clearly stated, I am directed to state that the exact area covered by permit number 191 of 1974 as per spot demarcation according to the boundary description done by the joint team consisting of Sandeep Gupta, Srilal Machuana, SO2, and Srilal Ringli and Aton Singh Survey 1 on 24/3/2003 is 29.48 bigas instead of 2 bigas. So this has been clearly established. It is not that we, the defendants, the plaintiff and the defendant number 1 were making a submission or a statement on the basis of surmises. It is on the basis of records of the state government, which was made on the basis of spot verification in the presence of the representative of the 107 RCC.
okay, this was it. Then,
So here,
uh,
however, the said permit was cancelled by the impugned letter dated 24/11/2015 by the Secretary to Government of Mizoram Land Revenue and Settlement without issuing any notice to the landowners. Said impugned letter dated 24/11/2015 was challenged in the connected civil suit number 59 of 2016. Hence, the said permit number 19174 would have to be held as a valid permit prior to the cancellation via impugned letter dated 24/11/2015. For all purposes, before its cancellation, it was valid, and now, when it was cancelled by the impugned letter dated 24/11/2015, the respondents 1 and 2 have no other thing but to challenge the validity of this impugned letter.
okay, so because of that, the civil suit.
Yes,
Oh, okay.
that was the only reason why civil suit was filed.
Oh.
Lordship, the next ground is ground 14 and 15 are taken together in a page 951 is appeal ground number 14. What they have stated is that there is no reason to accept the area of boundary of LSC number 103 of 1985 in the name of Bielzava, not covered the entire area of the land covered by permit number 191 of 1974. So it's clear that the Landed Trial Court has wrongly held that issue number 10, that whether the area and boundary of LSC number 103 of 1985 in the name of Bielzava, pro forma defendant number 5, covers the entire area of land covered by permit number 191 of 74 in favor of the plaintiff. Because 191 of 74, the dimension, the area covered has been clearly defined. And on the basis of spot verification, it was found that it was 29.48 48 bigas. But the area and boundary of LSC number 103 of 1985 in the name of Bielzava was not even 2 bigas. So the finding that the area of 191 of 74 is not the same as that of the area and boundary of LSC number 103 of 1985 are not the same, was the finding recorded by the Lanet Trial Court that has been challenged here in this ground. If I take a lordship to the statement which I have made in appeal ground in response to appeal ground number 14 and 15, I'll just read it. Area of land covered by the LSC number 10385 in the name of Bielzava covers an area of 2622.49 square meter. Give me.
So much square meter, square feet is 1.95 bigas.
Yes, 1.95 bigas by the revenue department, whereas permit number 19174 covers an area of 29.48 bigas as per the boundary description. Therefore, it is clear that LSC number 10385 did not cover the entire area covered by permit number 19174. It is reiterated that 2 P patas were issued from permit number 191/1974, which are P pata number 1 of 1977 in favor of Sri F. Bielzava, pro forma defendant number 5, subsequently converted into LSC number 103 of 1985. P pata number 57 of 1995 in favor of Lientudaya, as can be seen from order dated 3/10/1997. Exhibit P 35 and at page 430. Yeah. Which I have already read.
You've just read 431 is
Yes.
translated.
41 is a translated copy. The said P pata number 57 of 1995 was reverted back to its original status as permit number 191/1974 as the land falls within Aizawl town area. Therefore, it is clear that Sri F. Bielzava had only purchased a small portion of the area covered by permit number 191 of 1974, and all the remaining areas are retained by Sri Lientudaya, which was inherited by defendant number 1 after the death of the said Sri Lientudaya. Since the suit land presently occupied by defendant number 6 and 7 covers an area of 20.2 bigas as per the spot verification conducted by Lanet Trial Court, as per Exhibit C 1 and 2 at pages 733, 741. Lordship, this is a letter from Deputy Director to Srimati Grace Lalswandiki, Assistant Government Advocate, on the subject of submission of verification report. It is at page 733. The next is 734. Is the duty reports. That's your letter.
I think you've read this. You've already read this before. And we had corrected also. 737.
Yes.
101 should 191 should be recorded as 190.
Yes.
We have read this before. In the afternoon.
It's because of the repetitions made in the grounds. So
Yes.
we also, I suppose, to make some repetition.
So
in the
here I think
appeal ground number 16.
737. Yes.
What they have
But
stated is
Vidal,
that
before you proceed, this letter, this 737, 736, this is dated what?
7.3.
Duty report. Okay, it must be in 733. Verification.
This is a translation, Your Lordship. It is
The same date of the verification is not given.
at the top of the letter, 17/6/2022, Directorate of Land Revenue and Settlement. And
Where?
as per the attendance sheet at page 738,
738. Okay.
that it is
Oh,
on 25/5/2022.
25/5, 2022. So this was done on 25/5.
Verification was conducted.
Okay. It's quite recent.
Yes, because it has been done as per direction of this honorable court on remand. For that, the Land Trial Court at page 961, ground 16. The Land Trial Court failed to appreciate the spot verification report submitted by the Deputy Director or Director, Land Revenue and Settlement Department, Aizawl, Mizoram, through Srimati Grace Lalchwantaki. The duty report of Lalchandpur surveyor, who was detailed for conducting spot verification of the land in question, has been submitted before the court by Deputy Director for Director, Land Revenue and Settlement. In his duty report at para 4, he stated that permit number 191 of 74E, BRTF in block Chietan and Man, here Ningay ni in Alanga, at San Levang Su, and Noemi ang Hian, and Talangila. So, the spot verification reveals that the alleged permit location has already been acquired by BRTF award number. Said survey was cross-examined by counsel for defendant number 6 and 7. She deposed at the cross-examination that it is also a fact that, as per annexure 1 of the plan, the boundary of permit number 191 of 74 is the west. In the west is written as BRTF Lak China Il Takatan Payin and Paraten. That it's a fact that since the area of land in dispute has been changed with time, I admit that the suggestion put to me, the boundary of permit number 19174 and boundary mentioned in my spot verification could not be the same in the west side. And para 11, that it's a fact that I do not know exact boundary permit number 19174. And para 12, it's also a fact that I do not know the exact boundary of permit number 19174. And para 30, that is a fact that I do not know as to whether permit number 191 has been acquired by BRTF by the word number 989 as government freeland. Suppose, Lordship, the one who had conducted submitted his duty report, that is K. Lalchandpur surveyor, was not the authority, but he went to the spot and he had conducted the spot verification, and he had stated what he did know and what he did not know. That does not falsify. That does not falsify the fact of what he had stated in his examination in chief, which is at page 881.
881.
881. The relevant portion of his cross-examination by the counsel of the plaintiff may be reproduced as below. Number one, it's a fact that I was summoned by this honorable court to give evidence with regard to verification report submitted by me. It's a fact that permit number 682 of 63 was bifurcated into, namely,
Okay,
permit
this is the
190.
judgment, portion of the
This
judgment.
is part of the judgment.
Oh, okay.
It is reproduction of the judgment.
Okay, it's okay. So this is what is observed by the court, isn't it? So this
Yes.
is important. Reproduce it. Then court has taken note of this.
Yes. And on that basis, the dispute raised by defendant number 2 and 3 in that permit now was no longer exists as was already converted into P Pata number 1 of 1977. And thereafter, it was converted into LSC 103 of 1985 in favor of the pro forma defendant number 5. However, the evidence adduced by witness for defendant number 2 and 3 revealed that permit number 191 of 74 was reverted back to its original form from PPATA number 1 of 1977, as PPATA cannot be issued within the Aizawl town area. Further, the boundary description of permit number 191 of 74, originally issued to Lian Tudai, late father of the defendant number 1, and LSC number 103 of 85 issued to pro forma defendant number 5, are not similar inasmuch as the boundary description of permit number 191 of 1974 covers an area of 29.48 bigas, and the boundary description of LSC numbers and so covers an area of 28217.99 square feet, that is 1.95 bigas. Therefore, the only logical explanation which can be derived from comparing the two land passes that Lian Tudaya had not sold all his land to the pro forma defendant number 5, inasmuch as the boundary description of his permit number 191 of 1974 covers a much larger portion of land than LSC 103 of 1985. Further, considering the cross-examination portion of the court witness, Mr. K. Lalchan Puya, was conducted spot verification and measurement of the landed area covered by permit number 191 of 1974 clearly reveals that the area covered by permit number 19174 is 29.48 bigas, and after deducting the area of land covered by so-and-so belong to Bielzava, and LSC 1805-2006 belong to D. Lalin Tuanga, remaining area of land covered by permit number 191 of 74 is 20.2 bigas. Lordship, the judgment.
That's
of
the
this
reasoning made
court,
by the learned
yes.
tribe court.
In the case of Pachunga versus Chief Secretary Government of Mizoram, report in 2017, 4 GLT 144 has been taken as a defense in that regard. I'll come to all these rulings later. Now, if I take Lordship 2, round 16. In which I have stated that the spot verification report submitted by Deputy Director for Director of Land Revenue and Settlement Government of Mizoram through Srimati Grace Lalchuandiki clearly shows that the permit number 191 of 74 was demarcated at the spot. The said permit had originated from bifurcation of permit number 682 of 1963 into permit number 190 of 74 and 191 of 74. Said permits were divided by the old Aizawl Lunglei Road, which is now the approach road to Falkland Veng, since LSC number 103 of 1985 belonging to Bielzava and LSC 1805 of 2006 belonging to D. Lalintluang has been sliced out from permit number 191 of 74. The remaining area has been carefully demarcated at present. The area of the suit land is 20.2 bigas. Said verification report further revealed that permit number 19174 is the area utilized by BRTF as Block 3 due to the following reasons. A. As can be seen from the BRTF map, it appears that the area covered by permit number 19174 was occupied as a government land. On the western side, neighboring land is permit number 19074, and on the Zemabok main center side, neighboring land is LSC 10385, which was previously owned by Mr. F. Bielzava, which was later acquired by the BRTF. This clearly indicates that permit number 19174 exists between permit number 190 of 74 and LSC 102 of 1985. B. Since permit number 19174 and 19074 were bifurcated from permit number 682 of 63, it is apparent that they would be located next to each other. A perusal of the verification report clearly goes to show that defendant number 6 and 7 have illegally occupied the area covered by permit number 19174, thinking that it was a government free land. However, the said defendants have refused to acquire the said land or pay rental compensation in spite of several information being given to them by the state government to pay rental compensation. Such communications are at Exhibit P36, P36, 37, 38, pages 432, 442. Unfortunately, the state government had taken a U-turn by issuing the impugned letter dated 24/11/2015, cancelling permit number 191 of 1974 without affording any chance to the landowners to explain themselves. Hence, the plaintiff has no other option but to file the civil suit number 56 of 2016. This is why
This is where I'm questioning you. This is where I raised the question
yes,
that without giving them a chance, but in the writ petition, it was mentioned that a chance should be given to the to the petitioners
Yes.
also. If a chance was given, so you're saying without affording any chance, then in the content, you should have be afforded a chance. And if this is the result, you're unhappy, then the civil suit, of course. Yeah, that's the only point I'm pointing out.
this is,
But
yes.
what's happened
Lordship
has
had rightly
happened.
pointed out, had there been the opportunity given to the landowners at that point of time, the fate of the case might be different.
Might have been different.
But at this stage, my
things
humble
have
submission
gone,
is that
bridge over
so much of
waters.
water have flown. Now it is may not be appropriate for the appellate court to go back and direct the
But
matter to be
that
started
should have
afresh.
happened, no? Anyways,
And here, my humble submission is that, Your Lordship, since what was done, rightly or wrongly, an appeal has been filed from the first order.
where the contempt petitioner himself says that it can be disposed of, contempt petition, because the order had been passed. Anyways, leave it at that. Maybe
Yes.
it's a good
And now,
a point for argument
since
for
the matter,
the appellants.
yes, since the matter has been decided by the land trial court, and since an appeal has been filed, at this stage, if
This was
if
not
the
this
parties,
was not mentioned, pointed out in the appellate court also, no?
Yes.
Previously.
and this is not the grievance of the state government. State government is not aggrieved by the order passed by the land trial court. When the authority that passes the order is not aggrieved, whether the third party, that is the defendants number 6 and 7, who are the appellants now, can take up the
Yes,
matter
okay.
and expose the cause of the state government. This is how I have understood. It is not permissible for them to raise such issues at this stage. if the state who is the authority on that
Who
is
passed
not raising,
24/11/2015.
if the state is not raising such issue, then since the respondents, the appellants are simply occupying the land, thinking that it's a government wasteland. And when the court had come to the finding that it's not a government wasteland, it is a land covered by 191 of 74. Duly,
Yeah, anyway, so I've got
Yes.
your point here.
yes,
So civil suit 56, it should be appealed against by the state, which state?
State,
State
yes.
is not the appellant. Okay.
and appeal ground number 17, that's it. At page 963. For that the Lanet Trial Court wrongly decided issue numbers 11 and 12 that whether the power of attorney dated 24/10/2003 is valid or not, and issue number whether the deed of agreement dated 24/10/2003 is valid or not in favor of defendant number 1 and against the plaintiff. The Lanet Trial Court failed to appreciate the evidence on record by ignoring contention of defendant number 1 in his written statement. Lordship, here also, by filing the instant appeal, the appellant is trying to take up a cause which was no longer there between the plaintiff and the defendant number 1. Since they have made a settlement between themselves, it is no longer open for even both the defendant number 1 and the plaintiff to raise such issues at this stage. Now it is much less for the respondent, for the appellant to raise such issue by way of this appeal. There is no reason, there is no cause of action for the appellant. And appeal ground number 18. Seriously, for that the Lanet Trial Court has seriously erred in law in fact by passing the impugned order, wrongly declared that order dated 24/11/2005, cancelling permit 191 of 74 is illegal, null and void, without giving any reason, without any analysis of the facts that has been put before it. It has not come to any definite finding as to how the order dated 24/11/2005 is illegal, null and void. The Lanet Trial Court simply held that impugned order dated 21/11/2005 issued without affording opportunity to defend himself cannot be justified in any manner, and it is declared as illegal, null and void, while deciding issue number 14. This issue number 14, how it was decided, I have earlier read it. Now, I have stated here in the appeal ground number 8, the trial court, while setting aside the order dated 24/11/2015, had gone into the facts of the case and had also relied upon the judgment of the apex court in the case of Bharat Petroleum Corporation Limited versus Lalman Arsarma, reported in 2011-14 SCC 594, which deals with violation of principles of odi alteram partem, which is one of the cardinal principles of natural justice. Therefore, the contention of the appellants that Lanet Trial Court had decided the order dated 24/11/2015 is illegal, null and void, cannot be accepted in any manner. Moreover, the contention put forth by the appellants that the Secretary to Government of Mizoram, Land Revenue and Settlement was acting in compliance with the Honorable High Court order dated 1/5/2018 in connection with contempt case number 16 of 2015 is also unsustainable in law, inasmuch as the said order passed in said contempt case is only with regard to disposal of representation pertaining to issuance of house site outside the fencing area, which forms part of permit number 191 of 1974, filed by the plaintiff, who is the petitioner therein. Here, Lordship, may I just explain, because the matter connected with the contempt case, 16 of 2015, is in respect of the land which was covered, undoubtedly covered by permit number 191 of 74, but which is lying outside the fencing area. As the lordship noted. Therefore, the cancellation of the whole area of permit number 19174 by the said Secretary to Government of Mizoram Land Revenue Settlement on the basis of its perverse findings cannot be allowed to stand the scrutiny of law while the landowners, including defendant number 1, were not afforded an opportunity to defend themselves. Hence, the trial court had rightly set aside the impugned letter dated 25/11/2015. And appeal ground number 19, 20, and 21. At page 973, ground number 19 has been stated that the court has failed to appreciate and analyze the material facts surrounding the circumstances of the case and has also failed to appreciate fully the evidences that were made available to him during the course of civil suit while deciding issue number 15, that whether defendant number 6 and 7 occupied permit number 191 of 1974 without acquiring the same. Instead of discussing deposition as well as cross-examination by witnesses in order to ascertain as to whether defendant 6 and 7 occupied permit number 191 of 74 without acquiring the same, however, the learned trial court just simply reproduced the examination in chief as well as the cross-examination without having any definite findings. The stance of respondents 6 and 7 in the written objection at para 4 that headquarters chief engineer project Puspa located them since its inception. In the year 70, the office of Mizoram District Executive Department issued departmental pass number 4 of 1972 border organization for the temporary settlement while undertaking construction of road. And Lordship, this has been produced earlier, and this departmental pass number 4 of 1970 was valid only till 1 year in the 1971. And thereafter there was no extension, and the lands have been continued to be occupied. And here I have stated that the learned trial court, while dealing with issue number 15, 17, and 18, in order to fully appreciate evidences of the defendants, number 6 and 7 had reproduced their cross-examination, wherein the said witnesses in the statement clearly stated that permit number 190 of 74 was released to defendant number 1 on 7/12/2001, as no compensation has been paid to him. They also deposed that permit 191/74 was not acquired by BRTF at any point of time, clearly indicating that they had been in illegal occupation of the said land without any authority. Moreover, the said witnesses deposed that defendant number 6 and 7 have no grievances against the order portion in page 28 of Judgment and Order dated 5/4/2019, passed earlier by the Senior Civil Judge Aizawl, Judicial District Aizawl, in civil suit number 56 of 2016. In fact, the main reason for filing the previous RFA 16 of 2020 by defendant number 6 and 7 was upon the advice of the state government, state defendants, and they also admitted to the fact that BRTF does not have any land pass for Block 3 and of the office complex for Project Puspa, issued by Revenue Department Government of Mizoram. Apart from this, spot verification conducted by KLR Chanpuya Surveyor on direction of trial court also clearly reveals that the location of permit number 19174 is the occupied area of defendant number 6 and 7 as Block 3, as can be seen from pages 798 and 8262-844. I'll just read on. The Land Trial Court had also discussed as to how the whole area of permit number 191 of 74 has not been sold to Sri Bielzava, and that there exists a vast remaining area which was retained by the Antudaya. Since a mistake was committed by the authorities concerned while proceeding with acquisition in connection with the Ward number 9 of 1989, by showing the area covered by permit number 191 of 74 as a government free land, the mistake had to be corrected at any subsequent date in any manner. Consequently, the mistake has been corrected by Landed Trial Court by the impugned judgment and order dated 17/5/2023 in civil suit number 59/2016. Therefore, contention raised by the defendants number 6 and 7 has no value for setting aside the judgment and order dated 17/5/2023. In this connection, may I take Lordship to page 977. This is a continuation of ground number 19. At page 977, at the top, Lordship, if I read from therefore, therefore, there could be no more occupation of private land beyond acquired area by BRTF unless the state government committed mistake, which should be the dispute between the landowners and the state government only. What has been
But
stated?
there's no dispute.
977.
So here they said should be a dispute.
The dispute should be in respect of that land. It should be only between the state government and the landowners only. This is the moot point raised by the appellant. And what we have stated here is that the mistake was there. And when the mistake was not corrected by the state government itself, the corrective measure needs to be taken by way of a suit. And the Landed Trial Court had made the correction. May I read again?
Yes.
There could be no more occupation of private land beyond acquired area by BRTF unless the state government committed mistake. So the fact that state government committed mistake was very glaring. It has been pointed out by themselves on the basis of their verification. The only region where they have reverted back and cancelled their earlier finding is that on the basis of the instruction, only those portions of land for which revenue tax is paid could be converted for the purpose of issuance of P-Pata or the pass. If since the area has been shown as 2 bighas, irrespective of the boundaries, now the landowner would be required to pay only, revenue tax only for 2 bighas. Then if only 2 bighas revenue tax is paid, even if the area is much larger,
Okay.
then the question of extending will not arise. That is the reason why they have made cancellation of the finding that it is not 2 bighas, it is 29.48 bighas. That has been reversed only on that ground. And here, the mistake was there, it is very glaring, and it is also stated very clearly by the appellants that there could be no more occupation of private land beyond the acquired area by BRTF unless the state government committed mistake, which should be the dispute between the landowners and the state government only. However, learned trial court failed to appreciate the facts as shown, complete biasness while proceeding with the civil suit, and the findings are perverse and not based on evidence on record at all. This is the view propounded by the appellants. So when they say, unless there is a mistake committed by the state government, the question of the appellants occupying private lands will not arise, but it has been established on
So it
numerous
says, unless
fronts.
there's a mistake, but their stand is that there's no mistake.
Yes, the stand is that there's no
There's no
mistake.
mistake.
But if there is a mistake,
It should
it will
be
be for
between
the, it is between the government and the landowners, and we're not responsible for that. This is what they have been trying to say. So they are trying to shift the responsibility upon the state government. And the state government, having found that they have committed the mistake, they have done what was necessary under the law. And since the land, the private land, which was considered by them as a government wasteland, has been found to be a land under the rightful ownership of the defendant number one. Then it was found that the rental compensation should also be paid by the occupant agency. Lordship, those are the grounds and the there's much of repetition, but I think we have covered.
Now the authorities.
The authorities, Lordship, may I take Lordship to 2022 SCC.
Just make it larger, the script.
Oh.
It's very tiny, I can't see.
This is regarding the right to property, adverse possession, delay and latches. May I take Lordship to para 12?
Okay, go up to para 12.
Para 12 has sub clauses. If I take Lordship to para 12.11 at page 574.
0.11.
Yes. Wherein it is stated, we are surprised by the plea taken by the state before the High
Go up
Court.
0.11, 12.11.
Yes, 12.11.
This is 12.6. I can see up to 12.6. Yes. Yes. So here you're showing me till 12.9. Show me 12.11.
12.11. Is it visible now?
Yes.
We are surprised by the plea taken by the state before the High Court that since it has been in continuous possession of the land for over 42 years, it would tantamount to adverse possession. The state, being a welfare state, cannot be permitted to take the plea of adverse possession, which allows a trespasser, that is, a person guilty of a tort or even a crime, to gain legal title over such property for over 12 years. The state cannot be permitted to perfect its title over the land by invoking the doctrine of adverse possession to grab the property of its own citizens, and as has been done in the present case. Now, in this connection, the stand that has been adopted by the appellant is that the suit was bought by limitation, and they have been in occupation of the suit land for a number of years, right from 1970-71. And on acquisition in 1989, they have become the owner. So that was the plea that has been taken. Now the respondent number 1 had filed the suit in 2016 only, and it was much bought by limitation, according to them. So this adverse possession is one of the grounds used to be taken in such kind of cases. But what the law, what the apex court herein held is that it is not permissible for the state. Respondent numbers 6 and 7 are also the state. They are instrumentalities of the state. Union of India. We are surprised by the plea taken by the state before the High Court that since it has been in continuous possession, their possession is without title and without any payment of compensation and even rental compensation of the land for over 42 years. It would tantamount to adverse possession. This is the stand, similar stand has been taken by them. The state, being a welfare state, cannot be permitted to take the plea of adverse possession, which allows a trespasser or a person guilty of a tort or even a crime to gain legal title over such property for over 12 years. The state cannot be permitted to perfect its title over the land by invoking doctrine of adverse possession to grab the property of its own citizens, as has been done in present case. And point 12.12, the contention advanced by the state of delay and latches of the appellant in moving the court is also liable to be rejected. Delay and latches cannot be raised in the case of continuing cause of action, or if the circumstances shock the judicial conscience of the court. Condonation of delay is a matter of judicial discretion, which must be exercised judiciously and reasonably. In the facts and circumstances of a case, it will depend upon the breach of fundamental rights and the remedy claimed, and when and how delay arose. There is no period of limitation prescribed for the courts to exercise their constitutional jurisdiction to do substantial justice. In fact, Your Lordship, the decision which have been impugned is of 24/11/2015. Now, suit was filed in 2016. There was no delay. But the period of illegal and unauthorized occupation of the suit land was, it started way back in the year 1970-71 on the basis of the authority given by way of the lease, which lasted for 1 year. And
Now,
thereafter,
wait, when was that order issued saying that you have to pay rental compensation, the first order?
the first order was in 2004.
Orders
No,
were there which was not complied with, no?
it
Previous
was not
period.
complied with. It was in 2003, assessment was made,
Okay.
and in 2004, the correspondence was made, and thereafter, nothing was done. And 2010, another was made again
Okay, fine.
at page 46. And Your Lordship, may I take Your Lordship to 12.414. In Tukaram Kana Joshi versus MIDC, this court, while dealing with similar fact situation, held as follows. There are, quote, there are authorities which state that delay and latches extinguish the right to put forth a claim. Most of these authorities pertain to service jurisprudence, grant of compensation for a wrong done to them decades ago, recovery of statutory dues, claim for educational facilities and other categories of similar cases. Though it is true that there are few authorities that lay down that delay enlarges the citizen from seeking remedy, even if his fundamental right has been violated under Article 32 or 226 of the Constitution. The case at hand deals with different scenario altogether. Functionaries of the state took over possession of the land belonging to the appellants without any sanction of law. Appellants had asked repeatedly for grant of the benefit of compensation. The state must either comply with the procedure laid down for acquisition or requisition or any other permissible statutory mode. So the law has been clearly laid down even earlier. That was in Tukaram Kanajo C. in the case of 2013, 1 SCC, which has been quoted here. So, Your Lordship, it is the duty and obligation on the part of the occupying department or the authorities of the respondents number, the defendants number 5 and 6 and 7, to pay rental compensation for the period of their occupation. They cannot simply cut short that we are in occupation from this period only, and you have claimed this only from this period. But the fact remains that the landowners have been agitating all along. And the second case, Your Lordship, is 2011 10 SCC. For us, 33 and 2011 10 SCC 404. Para 33 and 34. Is it visible, Your Lordship?
Yes.
May I read Para 33? The right to property is now considered to be not only a constitutional or statutory right, but also a human right. Human rights have already been considered in the realm of individual rights, such as the right to health, right to livelihood, right to shelter and employment, etc. But now human rights are gaining a multifaceted dimension. Right to property is also considered very much a part of the new dimension. Therefore, even the claim of adverse possession has to be read in that context. 34. The changing attitude of the English courts is quite visible from the judgment in Bew Lane Properties Limited versus Palmer. The court here tried to read the human rights position in the context of adverse possession, but what is commendable is that dimensions of human rights have widened so much that now property dispute issues are also being raised within the contours of human rights. With the expanding jurisprudence of the European Courts of Human Rights, the court has taken an unkind view of the concept of adverse possession. Lordship.
Okay, next.
Two 2006 5 SCC. Page 466. Para 6. Lordship. This is regarding the area, whether it has to be taken as per the boundary description or the statement that it is of this much. In para 6, may I read the Lordship?
Yes.
The High Court has also upheld a title claim by the plaintiff over plot number 1301-1BA. Once we accept the identification made by the Commissioner, as was done by the First Appellate Court, it is clear that the plaintiff has the right to have the disputed construction removed and the well filled up. That a property can be identified either by boundary or by any other specific description is well established. Here, the attempt had been to identify the sued property with reference to the boundaries, and the Commissioner has identified that property with reference to such boundaries. Even if there was any discrepancy, normally the boundaries should prevail. Boundaries should prevail. Now, there is no dispute about the boundaries of the permit number 191 of 74. So, though the area of 191 of 74 was shown only as 2 bighas, but when measurement and demarcation was taken at the time of spot verification, it was found to be 29.48, including the 2 pipatas. Now, excluding the 2 pipatas, it has come down to 20.2 bighas. So, that is, the finding was on the basis of the boundaries. So, when there is a dispute as to whether the boundary should be taken into consideration or the statement in the past, it is the law
Yes.
laid down by the Apex courts that in such cases boundaries should prevail. And this has been followed by a number of cases decided by this Honorable Court, even in the case of Ze Pachunga, Chief Secretary to Government of Mizoram, 2017 for GLT. Page 1044.
Yes. So where's the operative one?
If I take Lordship to para 13,
13. Oh.
para 13, on a consideration of the whole aspect of the matter, only issue that requires consideration of this court in the present appeal is whether the dispute with regard to the area should prevail or the boundaries that is described in the mispass number 12/1970 would prevail. The law being already settled in this respect, this court holds that the boundaries described in mispass number 12 of 1970 shall prevail, and appellant shall be entitled to occupy the area that falls within the boundaries described in mispass number 12 of 1970. So, in this, the numerous decisions
Okay, same principle was
Reference has
taken
been
in
made
these
to-
2, 5 and
yes.
6. Is it? Just leave it like that?
yes, Lordship,
Boundary.
2006 5 SEC 466 Subaga and others has been relied upon,
Oh,
and the case of Srimati VL Buki versus State of Mizoram and others. It was decided by this Honorable Court in WPC 7 of 2007. It's
dated?
also
Dated?
dated,
The date, we don't, okay.
VL Buki is dated 1/4/2009.
And the other one, Malswami Pautu,
Malswami Pao 2,
date of the judgment? Any idea?
lots of Malswami Pao 2 is WPC 109 of 2009, dated 5/5/2011.
Okay. Same principle, so no need to read
Yes.
the whole judgment.
Lots of these are spare copies.
Okay, we can have a look.
These are judgments rendered by our own high courts in connection with those cases. Now, let me try to sum up.
Yes.
The points that needs to be addressed by this honorable court as can be appreciated on the basis of all that has been stated, is that whether the appellant would have right to occupy the unacquired portion of land covered by permit number 191 of 74. Whether the appellant would have right to
Okay.
Yes.
Okay.
occupy the unacquired portion of land covered by permit number 191 of 74. If so, on what basis? Number two, whether there was mistake committed by the state government in not considering a vast plot of land for acquisition in connection with award number 9 of 1989. If so, whether the same can be said to have been corrected by the authorities concerned by taking redemarcation of the area of permit number 191 of 74. So the issue that was raised by the appellant under ground 19 was that there was no mistake committed by the, we're not, occupying any plot of land, any plot of private land which was not acquired, except under the condition if there is a mistake committed by the state government. Now, the fact is clearly highlighted that a mistake has been committed, that portion of land other than 2 bighas covered by permit number 191 of 74.
So there was this thing, isn't it?
Yes,
verification
there was a mistake.
as recently as 2022, I think, something very recent.
Yes, that has been corrected by the state itself by taking
Verification, a recent
re-verification.
one, 2022.
Yes, 22. That 22 has clearly indicated that it is not 29. Now it has come to 20.2 bighas. And the third thing that needs to be addressed is that whether the appellants have assailed the validity of the findings recorded under Exhibit D18. Exhibit D18 is the finding of the authorities concerned. With the direction that since they are occupying the private land for a number of years since 1963, they need to pay rental compensation at this rate, and the rate of assessment that has also been shown. And
D18 is dated.
D18 is dated 17/2/2004. That page 5.
This is all
538.
before the civil suit, no?
538, yes, recast. Exhibit D18. And direction was made.
So concerning D18, where's the issue framed by the court after the recast petition? Any issue framed regarding D18? Many issues were framed, isn't it, by the trial court?
Specifically,
If no issue was framed concerning
the only
this,
issue,
then not decide, then we don't have to touch upon this. The learned trial court in the impugned order, impugned judgment and order, did frame an issue on this point, D80, compensation?
Yes. Whether defendant number 6 and 7 are liable to pay rental compensation to the plaintiff, as can be seen at page 869.
Okay. And the court in issue 16 was decided in your favor.
Yes.
Okay, to be paid. Ah, okay.
Whether the appellants have assailed the validity of the findings recorded via Exhibit D18 before any forum. If not, whether the instant appeal is maintainable. The only reason why they have appealed, well, they have filed the instant appeal is that since they have been in occupation of the suit land, and since they have been required to pay so much of the rental compensation, trying to avoid that liability, they have come forward with this appeal. Now, whether the appellants have assailed, since they have not assailed the findings recorded under Exhibit 18, D18, whether the appeal is maintainable at all. This is the moot issue that needs to be addressed by this Honorable Court. So in view of all that has been said, Lordship, my humble submission is that the appeal is without any merit, and the judgment and order which has been impugned in the instant appeal needs to be upheld. Obliged.
Yes.
So you don't.
I think you are going to adopt most of the submissions.
Hello, I'm for respondent number 2. Since respondent number 1 and 2 are sailing on the same boat, fighting for justice for the past few years, having common enemy, all the submissions made by the learned senior counsel may be adopted by me. The only point I would like to submit to your lordship is, as we can see from the records, taking into account the documentary evidence as well as the oral evidences adduced by the rival witnesses, the appellants do not have any valid pass at all. They do not have any pass in respect of the land occupied by them illegally for the past many years. And in order to file the present appeal, also, they do not have any valid ground to base upon the valid pass, my lord. If that is the case, then the instant appeal is without any merits. It should be dismissed with exemplary cost. And apart from that, my lord, although I have something to submit to your lordship, I may rely upon the submissions made by the learned senior counsel.
Okay. Yes. Rebuttal?
Sit down. Sit down. If I may, my lord, I may be respond to 3 lines only. Regarding pass, we have a pass. At the time of acquisition, we are given land certificate. That was at page 535. If I may read, my lord,
Page 535.
535.
Oh.
And here, 161.50 bigas has been given to us. This is a certificate of land for the whole acquisition of land. Then, however, the main reason is that in the last sentence of that certificate, the terms and conditions of the actual allotment will be governed by lease deed between the state of Mizoram Revenue Department and BRTF. My lord, even though that acquisition has been done in the year 89, till date, the state government unable to prepare a list this in some block of acquisition proceeding. Due to the lethargy and due to unfair means of the state respondent, my lord, even though acquisition had already been done in the year 89 and land certificate was issued to the BRTF, however, they cannot compliance with the sentence that I read out, my lord.
This is the area is what?
Area for 161.50 because the whole area of acquisition, my lord.
161.
Yes.
That's very huge.
Now here, my learned friend stated that the BRTF admitted they have no valid pass. That was not our submission, my lord. We have a pass, we have a land
The
certificate.
boundary of the pass, anything?
Yes, my lord, map is also there.
Okay.
We enclosed the map
There's the
also.
map. Ah.
Yes.
So within this map, where's the disputed area? Can you point out?
Yes, my lord. Because we already acquired the land, then we have a given land certificate. The main reason is that that land certificate should be governed by lease between the state and BRTF.
lease.
That
Lease
lease
not
is
issued.
still awaited from the state government. Even so many reminders have been sent to
This
them.
is 2003.
That 2003.
Okay, so now this is the landed area.
Yes.
So now the present dispute, this is very huge. So the
Yeah, my
present
lord,
dispute
if
is
I
in
may,
which part?
if
Which
I may.
portion?
Now, my landed friend openly admitted what had been happened. However, my lord, at page 58, my landed friend, my landed senior counsel already read out this one. Here in the block 3, what they are targeted, the area is 29, as per joint verification at page 58. The area is 29.48, which exactly the area they are trying to increase the land from 2 bigas to
Page 58.
page 58. That is verification report. In, coincidentally, the area of the block 3 and the area of the claim land,
29.48.
yes, 49, exactly the same area to this. That is why they now have common intention against Union of India for trying to extort money from Union of India unfairly, my lord. That is punishable, my lord, if the state government also admitted what they have
The area of
done.
block 3 already been evaluated.
Pass 191 of 74 was enhanced and converted into the exact area of this block 3, my lord, the total area of this block 3. Then that it is very clear now. They challenging the government, the state government order 2014. However, the state government not yet filed appeal. However, they trying to say that in their letter sent to BRTF, we will take action from our side through our council. In the meantime, you are also requested to file appeal so and so to your council immediately. Then now they kept silent, my lord.
But what about, there was one, this thing, isn't it? Letter.
Zhao Mingao,